Hi, my name is Deanna Clark, and I'm the Managing Attorney of the Clark-Esposito Law Firm. I'm here today with Debra Weiss, our Senior Customs Attorney, and we're here to do a video for you entitled, Think You Want to Ignore a Customs Request for Information? Think Again. We wanted to do this video for you because we were thinking about how our clients feel when they have received one of these. And I'm going to refer to this as an RFI interchangeably with requests for information throughout the video. We thought about our clients, and just to help you understand, imagine you could wave a magic wand and you weren't worrying about the next question that US Customs was going to ask you. You were able to sleep through the night and wake up feeling refreshed and really rested. And you were going to work feeling secure that your business operations were running as they should be. Instead of feeling like Customs was taking you down a rabbit hole and you were being dragged into it, wondering what's next. Losing another night's sleep, wondering what US Customs is going to do with your next shipment. And being worried about the potential of a full-blown audit blowing up in your face any day now. Well, the good news is you can choose. You can choose what to do about this RFI. Debra and I are going to go through some questions right now with you to give you more information about what they are and what you can do. Debra, hello.
Hi, Deanna.
So my first question for you is, what is a request for information?
When an importer files an entry, it provides certain information to Customs about the shipment, about the merchandise, and the underlying transaction. If Customs wants additional information, it'll issue what's called a request for information, or otherwise a CF-28. If Customs issues such a document, is actually usually looking for a very specific issue or violation of Customs law or regulation.
That was a great description, Debra. Now tell us, why would somebody get a request for information from US Customs?
Well, it could be that Customs is suspicious about the importer. They've seen some issues on entries that they just need more information about. Or it could be that they're investigating the industry as a whole or another participant in the supply chain, such as a freight forwarder or the shipper, or otherwise it just could be random.
Well, that sounds straightforward enough. But what happens if somebody elects to not respond to a request for information?
The pertinent regulation just says promptly, which means that the Customs officer who issued the request for information has the discretion on how much time to allow. Normally, it's 30 days if the shipment is relatively recent, within the time to contact Customs about it. However, once an importer does contact Customs, then often extensions of time are granted.
So how much time does a party have to respond to a request for information?
Initially, the matter would be referred to the Fines, Penalties, and Forfeitures Office. They would issue a demand for liquidated damages for a breach of the importer's bond. One of the conditions of an import bond is to provide information and documentation to Customs upon request.
Well, that doesn't sound like a ton of time. What happens if an importer decides not to respond at all?
The FP&F office can also issue a penalty case for the same infraction. It seldom does issue both, but it's a possibility. Secondarily, the importer can face additional adverse action, like delayed shipments, extra examinations, or possibly put on the list for a focused assessment audit.
Now, what about calling the port? To do or not to do?
Well, it's much better for an attorney who practices customs law or a conscientious customs broker to communicate on behalf of the importer. We would know what to say to respond to their questions and what information would be superfluous. The attitude that I have nothing to hide may be a serious mistake. Inexperienced importers may not know what violations are hidden in their records.
So we got your take on whether or not to call the port. Do you have any tips on things you should or shouldn't say when contacting US Customs or communicating with them?
I can't stress enough that an importer use the services of a customs expert to prepare the response to the request for information. In essence, an attorney or a broker will respond as narrowly as possible to customs questions. Any additional information will likely be investigated further and lead to additional adverse action, such as an FB&F case or intensive examinations of subsequent shipments.
Debra, this has been terrific. So last question. How should an importer follow up after submitting their response to request for information?
Well, Deanna, each request for information will cite a specific entry or entries as a target of the inquiry. When an importer or its attorney or broker reviews the details of the importation, they'll likely discover evidence of violation. Then they'll realize that certain other previous entries contain the same violation. Customs will be aware of those entries.
Right.
Yeah, it's in the importer's best interest to file a prior disclosure to admit those errors, mistakes, before Customs initiates a formal investigation. In most cases, filing a prior disclosure will prevent the assessment of penalties.
Debra, this has been terrific. So listen to everyone watching. If you've received a request for information and you're not sure what to do about it, how to answer it, what you should or shouldn't do, reach out to us. You can contact us by telephone at 917-546-6997 or by email at contact@clark-esposito.com. We're determined to help you.
Subscribe and click the bell icon so you'll be the first to know when we upload a new video. Check out our playlist if you want to see more of our videos, and comment below and introduce yourself. We'll see you soon.